Everyone, we will begin in a few moments. Please note that audience members can submit their questions using the Q&A feature here on Zoom. We also invite you to use the chat feature to provide additional thoughts and comments throughout the program. Let this also serve as a reminder that today's program will be recorded, and we ask that all guests follow FTF's Code of Conduct and anti-harassment policy, and we will post that in the chat and can also be found on our website. All right, everyone, welcome to the Future of Privacy's 11th Annual Privacy Papers for Policymakers. We gathered today to recognize this year's leading privacy research and analytical work that is relevant to policymakers in the United States Congress and at U.S. federal agencies and data protection authorities internationally. We are excited to host a series of conversations today featuring paper authors and important stakeholders in the data protection field. And while this is FTF's 11th PPPM, this is our first virtual PPPM event, a necessity given how much the world has changed since we last met. My name is Marcus Assaling, a law and policy fellow here with the Future of Privacy Forum and the MC for today's event. I would like to thank the National Science Foundation for their support. I would also like to thank our honorable co-hosts, Senator Markey and Congresswoman DeGette, co-chairs of the Congressional Privacy Caucus. And of course, a special thank you to Elizabeth, Nicole, and Jeremy here at FBS and the Rational 360 team for your hard work and guidance throughout this whole process. A couple of opportunities that perhaps are also of interest. FBS announced recently a call for nominations for our second annual Research Data Stewardship Award, recognizing privacy-protected research, collaboration between companies and academic researchers. The goal of this award is to honor data sharing initiatives and to promote a cultural understanding of why it is important to business and societal interests to make data available for academic research. To nominate a project or to learn more, visit fpf.org. Also, FPF is working with Pepper Conference, which is an open call for participation. Pepper is an influential conference focused on designing and building products and systems with privacy and respect for their users and societies in which they operate. Please see the FPF website for more information. And a few quick housekeeping notes before we begin. Each paper's author and discussant will review their winning paper for 10 minutes and then open up to respond to audience questions for about 5 minutes. Audience members can submit their questions using Zoom's Q&A feature. We also invite you to use the chat feature to provide additional thoughts and comments throughout the program. And with that, I'd like to hand it off to Jules for a quick introduction for our keynote speaker. Jules.
Thanks, Marcus, and for everything you did to help pull this event together. This becomes a harder and harder event to do every year because we get a significant number of papers. Academics around the world, because of the incredible role data is playing in just about every aspect of society, are increasingly turning their interest to these challenges. And for many of us who work day to day, either in the politics of legislation or in the corporate compliance or in the advocacy world, we're running around to and fro, and it can be hard to take the time and really pay attention to some of the deep and valuable thinking that academics are doing. So we're delighted that this has become a real challenge, thanks to the members of our advisory board and the judges who stepped up from diverse backgrounds and diverse sectors to choose these. Every year I do take a look. I wonder, did the corporate judges all vote for one sort of paper, and did the civil society or academic? And it has always been the case, frankly, that there ends up being a lot of unanimity when people are looking at a paper, whether they agree or disagree or debate. And if the question is which papers really mattered, which had an impact, which do you hope that policymakers like FTC leaders, like Hill staff, like others take the time to read. So thanks to all of you who are taking a little bit of a pause in a really busy year to do a little deeper reading. And for those of you who didn't do the deeper reading, thanks to our authors and discussants. I'm really honored. I'm going to get out of the way because I'm super excited that we have with us the acting chair of the Federal Trade Commission, Rebecca Kelly Slaughter. I'll say just this. I wish we could have used perhaps some of Commissioner Slaughter's dissents as examples of policy papers to sort of put into this mix, because I think, like you, many of us have been reading the dissents that she, sometimes with Commissioner Chopra, sometimes in the lead, has set out over the past couple of years, urging the FTC to use its authority to the maximum, to do more to seek redress for consumers, to be more effective at providing oversight. I'll let her get more into that, but I will just suggest that after you hear from her about how she's thinking about some of these issues, recommend go back and pull some of the opinions, because they really are a fascinating roadmap for how the FTC can live up to its mission and goals of being the most effective enforcer for consumer privacy and other issues. So without further ado, I'm really delighted to introduce and hand over the podium here to FTC Acting Chair Rebecca Kelly-Slaughter.
Thank you, Jules. I appreciate that introduction, and you basically covered everything I was going to say, so I could make this really brief, but I won't, to your perhaps chagrin. I'll try to get into a little bit more detail, but first I do want to thank you all for having me here today. I've been the acting chair of the FTC for all of about 3 weeks now, and this is one of my first speeches in that capacity. I'm really excited to have the opportunity to lead the FTC in these challenging times, and I'm excited to be able to talk about privacy and data security, because these issues are so important to consumers, to the FTC, and to today's information economy. You do, as Jules teed up, have a full program ahead of you discussing the excellent papers on today's agenda, so I'm going to direct my remarks instead to some of the questions you may be asking and that Jules teed up about. Where is the FTC headed? What's new and different at the FTC under the new administration? And what should you be anticipating from us? So with the important reminder that my colleagues on the commission each have their own very strong opinions on these questions, I do want to take a moment to talk at a high level about my own priorities. So I'll start by talking about my interest generally in more effective and efficient enforcement strategies, particularly in the area of privacy and data security. And then I'll say a few words about two substantive priority areas for me. First, responding to COVID, and second, combating racism. So first, let me talk about effective and efficient enforcement. Back in August, which feels like approximately 6 pandemic years ago, even though it was about 6 months ago, I testified before the Senate Commerce Committee in support of comprehensive data privacy legislation. It's not the first time I've raised that view. It's not going to be the last time. I think the need for federal privacy legislation has only grown as the pandemic has pushed more of our work, our children's education, and our personal interactions online, which exacerbates data risks. But in the meantime, we need to think creatively about how to make our current enforcement efforts even more effective. The FTC has worked really hard to curb abuses in this space without the benefit of a federal privacy law, and for most of the statutes we enforce without civil penalty authority. But the questions about which I care the most as we move forward are, first, are we doing everything we can to deter future violations, both by the particular company at issue and by others in the market? Second, are we doing everything we can to help wronged consumers? And third, are we using all the tools in the FTC's toolbox to fully charge offenses and to pursue misconduct? I've supported many of the Commission's recent privacy and security cases, like Equifax and TikTok. But as Jules suggested, for those of you who followed closely, you know that I dissented in cases like Facebook, YouTube, and Zoom. Where I dissented, in most instances, it was because I believed the Commission should have obtained stronger relief for consumers, including by pursuing litigation if we're unable to negotiate sufficient relief in settlement. I want to highlight two types of relief I want us to seek, and I believe we can achieve in data privacy and security cases. And those are meaningful disgorgement and effective consumer notice. The Commission achieved an important and innovative disgorgement remedy in our settlement with the photo app Everalbum, which was announced last month. In that case, we alleged that the company violated its promises about the circumstances under which it would use facial recognition technology. As part of the settlement, the Commission required that the company not only delete its data, but also delete facial recognition models or algorithms that were developed with users' photos or videos. We routinely obtain disgorgement of ill-gotten monetary gains when consumers pay for a product that's marketed deceptively. EverAlbum shows how we can apply this principle to privacy cases where companies collect and use data in unlawful ways. We should require violators to disgorge not only the ill-gotten data, but also the benefits, here the algorithms, generated from that data. A good example of the kinds of notice provisions I like to see is the Commission's recent Femtech case involving the Flow menstruation and fertility app. We allege that Flow violated its promises not to share consumer sensitive information to third parties by sharing that information with Facebook, Google, and others. An important remedy the Commission achieved in this case was to require the company to notify consumers of its false promises. Notice lets consumers vote with their feet and helps them better decide whether to recommend a service to others. Finally, and crucially, notice accords consumers the dignity of knowing what's happened. There's a fundamental equity issue here. Many people, including those who most need to know, won't hear about the FTC's action against the company they deal with unless the company tells them. So I'll be pushing staff to include provisions requiring notice in privacy and data security orders as a matter of course. The other lesson we can take from Flow is the need to fully plead all law violations. As I mentioned in my joint statement with Commissioner Chopra on that case, I believe we also should have applied the health breach notification rule to the facts in Flow, and I'm glad we're conducting a review of the rule, which requires vendors of personal health records to notify consumers of breaches. In other cases, I've argued that we should have included unfairness count. In all of our cases, I want to make sure we're analyzing all of the relevant laws and pleading all the violations that are applicable. Finally, I think we need to think carefully about the overlap between our work in data privacy and in competition. Many of the largest players in digital markets are as powerful as they are because of the breadth of their access to and control over consumer data. The FTC has a really remarkable structural advantage over our counterparts in jurisdictions that focus exclusively on antitrust or exclusively on data protection. Our dual missions can and should be complementary, and we need to make sure we are looking with both privacy and competition lenses at problems that arise in digital markets. So on all these fronts, I'm encouraging staff to be innovative and creative to ensure we are using the full panoply of tools available to the FTC in order to bring about the best results in our cases. We welcome your insights as researchers, including feedback as to which remedies best address particular types of harm and feedback on the effectiveness of our existing orders. To gather this feedback, I've asked staff to plan a workshop aimed at increasing our understanding of the incentives in the marketplace and how best to ensure market players do a better job of protecting privacy and securing consumer data. In addition to ensuring we're being as efficient and effective as possible across the board, I want to highlight two substantive areas of priority for me. The first is the pandemic. It's been almost a year since many of us stopped commuting to work, going to restaurants, traveling, or seeing loved ones in person. Some 27 million Americans have been diagnosed with COVID, and almost 500,000 have died, even as the rollout of effective vaccines gives us new hope for the future. Responding to COVID requires an all-hands approach nationally, and the FTC has several important roles to play as part of the solution. Obviously, health concerns are paramount, but the pandemic is also fundamentally tied to a host of other challenges Americans are facing, ranging from COVID-related scams to privacy and security issues to an economic crisis. Let me identify a few areas I'm working closely with staff to pursue related to the pandemic. First is Edtech. With the ubiquity of distance learning during the pandemic, the Edtech industry has exploded. In 2020, U.S. Edtech startups raised over $2.2 billion in venture and private equity capital, a nearly 30% increase from 2019. Speaking from experience, we've got two kids in Zoom school right downstairs here. Parents and children are relying on Edtech more than ever. So what can the FTC do in this space? Oh, wait, okay. I was told my audio got disconnected, but now I think you can hear me again, so I'm gonna keep going. Great, unless somebody comes back in. I was talking about Edtech. What can we do in the Edtech space? Here are some things we have done. We've put out guidance for parents, schools, and Edtech providers on protecting privacy. We're conducting an industry-wide study of social media and video streaming platforms in which we've asked recipients questions about Edtech services they provide. And we're currently in the process of reviewing the COPPA rule, where we received numerous public comments. Okay, hopefully I'm back. Hopefully you can hear me now. Sorry about that. Welcome to 2021. Appreciate your patience. My internet cut out last week and it took my kids totally out of school. So I know we're all in the same situation. So let me go back to what we were doing on COPPA. I was talking about, we've gotten questions asking us to clarify how COPPA applies in the EdTech space. And I just need to say, we don't need to complete our rulemaking to say that COPPA absolutely applies to EdTech. And companies, I don't have a cat filter, it's true. And COPPA applies to EdTech, and companies collecting information from children need to abide by COPPA. And finally, we have to remember there's an important equity angle to EdTech too, which is exacerbated by the pandemic, which I'll discuss in a little more detail a little later. Second, I'd like staff to take a close look at health apps, including telehealth and contact tracing apps. As in-person doctor visits have become rarer during the pandemic, more consumers are turning to telehealth apps and other apps to help them manage their health issues. A recent UK survey found that usage of health apps has increased by 37% since the pandemic began. I already mentioned Flow, which happens to be our first health app case, but I'd like to see the FTC pursue more of these types of cases. And finally, in 2019, we embarked on an industry-wide study of broadband privacy practices. As businesses, schools, governments, and communities have struggled to find new models for staying open, providing critical services, and keeping in touch, the importance of reliable internet has grown. The largest ISPs added over 1.5 million customers in the third quarter of 2020, the last quarter for which statistics are available. Given the urgent need to provide the public with some transparency regarding the privacy practices of these companies, I'd like the Commission to issue a report on this subject this year. So the second and related priority issue I want to emphasize is racial equity. How can we at the FTC engage in the ongoing nationwide work of righting the wrongs of 400 years of racial injustice? I've been speaking frequently about ways to attack systemic racism through antitrust law, but of course there's a lot we can do on the consumer protection side as well. There's an overlap between racial equity and the COVID-related privacy issues I mentioned above. Among the things we know about COVID is that the pandemic is exacerbating the equity gaps in this country. One way that's true is in the world of the digital divide. As many as 1 in 6 kids lack equipment necessary to participate in distance learning, and nearly a quarter of kids lack reliable internet access, conditions that particularly affect rural, urban, and low-income families. We also know that digital services can sometimes target vulnerable communities with unwanted content, and that vulnerable communities suffer outsized consequences from data privacy violations. We need to be wary about the ways in which lower income communities are asked to pay with their data for expensive services they cannot otherwise afford. There are also several other ways we can focus on closing the equity gap. One is algorithmic discrimination. Kate Crawford at Microsoft Research wrote an article a few years back with the memorable title, Artificial Intelligence's White Guy Problem, in which she wrote, histories of discrimination can live on in digital platforms, and if they go unquestioned, they become part of the logic of everyday algorithmic systems. And research published in Science in 2019 demonstrated that an algorithm used with good intentions to target medical interventions to the sickest patients ended up funneling resources to a healthier white population to the detriment of sicker Black patients. Again, you could imagine that this is an area where the pandemic has made inequity worse. Although this research was published pre-COVID, these potential effects will be worse in the pandemic-driven reality where communities of color have been disproportionately disadvantaged. As sophisticated algorithms are deployed in ways that impact people's lives, it's vital to make sure they're not used in discriminatory ways. The Commission has begun to engage in this area. For example, we issued a report a few years ago with guidance for businesses on illegal uses of big data algorithms, including discrimination. And just over a year ago, I gave a speech at UCLA Law discussing the myriad harms of AI and algorithmic decision-making. And a few months later, our Bureau of Consumer Protection staff issued excellent new guidance on best practices in using algorithms, including transparency, fairness, and accountability. Going forward, I've asked staff to actively investigate biased and discriminatory algorithms, and I'm interested in further exploring the best ways to address AI-generated consumer harms. Another challenge we're facing is the development and deployment of facial recognition technologies, which can exacerbate existing racial disparities. The privacy implications of technologies that allow the identification of previously unknown individuals are obvious, and I know this forum has done a lot of work on this issue. There's clear and disturbing evidence that these technologies are not as accurate in identifying non-white individuals, and on at least 3 separate occasions, Black men have been wrongfully arrested based on faulty facial recognition matches. The Commission has challenged illegal practices relating to the use of facial recognition technology in the Facebook and Everalbum cases, and will redouble our efforts to identify law violations in this area. Finally, last summer, several news articles emerged about mobile apps' use of location data to identify characteristics of Black Lives Matter protesters. This raised a firestorm on the Hill, with several members of Congress asking questions about this practice. I'm concerned about misuse of location data generally, but in particular as it applies to tracking Americans engaged in constitutionally protected speech. So these are just some of the privacy-related priorities about which I'm passionate. I am deeply honored and grateful to lead the FTC at this critical time, and I'm excited to continue and expand upon the agency's great work. And let me acknowledge too that the FTC is by no means working on these issues alone. In particular, I want to thank the researchers whose work will be highlighted in today's program. Your work and that of privacy and security researchers like you is critical to the FTC's mission. For many years now, the FTC has hosted our own annual conference, PrivacyCon, to shine a spotlight on the latest research, and this year's event will take place virtually on July 27th. Privacy scholarship is tremendously valuable to us in myriad ways, bringing transparency to an all-too-opaque ecosystem and shedding light on policy alternatives or solutions. Thank you for the work that you do, and I look forward to more partnership going forward.
Thank you for that wonderful way of, hey there, it wouldn't be fun if there wasn't some, okay. Boy, I remember when he was
Zoom school.
You brought him to he was a tiny baby when I think you brought him to the FBF advisory board meeting that, how many years ago? 3, 4 years ago? 5 years ago? Boys rock, awesome.
This one is almost 9.
Oh, he's the older one.
Amazing.
Yeah. Thank you for that really great look at the super ambitious agenda. How might this agenda be impacted? And I'll ask just one quick question before we turn to the papers and let you jump to both the rest of the day of the chair as well as the day of the Zoom school parent. The upcoming Supreme Court case that AMG Capital Management versus FTC threatens to curtail some of the primary authority the FTC uses. Love your reaction to what that would mean if it went one way or another, and how you sort of see the challenges of that case.
Yeah, so I think it's a great question. We are really sensitive to the assault on our 13B authority in the courts right now. At the Supreme Court level, there are a couple of bad circuit court decisions. It affects not only our ability to get equitable remedies, so monetary redress for consumers, but also can affect our ability to go into court and get injunctions to stop bad behavior. This is some of the most important work that the FTC does. And the threat of losing those authorities is real and material to us. So we're doing a couple things. First, on a bipartisan basis, we're asking Congress to help fix what we think are really erroneous interpretations in the courts. And second, we're trying to dig within our toolbox and make sure that we are deploying authorities that maybe we haven't used as frequently before. For example, under Section 19 or 5M1B, to make sure that we are still pursuing violators as effectively as we can. I think we see it as a both at the same time strategy. We're not going to rest on the authority that we have, nor are we going to fail to take action if it were to disappear. But we also hope that Congress will step in and clarify the law, because really at the end of the day, it's consumers who lose out if we can't bring our cases as effectively as we would like to.
Thanks. And again, thanks so much for taking the time with us. As I mentioned to the staff and to you earlier, we were so excited when we saw your elevation to the acting chair. And then we're like, oh my God, her life just got even busier than ever before with all the challenges of the broader role. So we're delighted that you were able to continue to join us, as well as to really set out this ambitious agenda. We look forward to following your next steps. So thank you. Great to have you with us.
Thanks for having me. And just in case anyone was worried about the messaging that we get in our household with our little Boys Rock sign here, Teddy has 3 sisters, so he's trying to make sure that people do not forget his place in the household. But thanks for your patience with my technical and other logistical difficulties. It's really a pleasure to be here.
Good to see you. Thanks. And Marcus, over to you to help queue up the next steps in our program.
Thank you, Jules, and thank you, Acting Chairwoman Slaughter, for your time and great insight. And congratulations again on being named Acting Chair of the Federal Trade Commission. In our next segment, we will hear from the winning authors of the 6 must-read privacy papers from 2020. These papers were chosen by a committee of expert reviewers from FCF's advisory board, hailing from industry, academia, and advocacy organizations. Judges not only chose winners based on their best scholarship, but also the scholarship that would be especially useful for policymakers like the chairwoman. These papers provide new frameworks, practical suggestions, and concrete solutions to policymakers both in the US and abroad. During this segment, the authors of the winning papers will be joined by discussants. They will again engage in a 10-minute conversation about the paper, followed by a 5-minute Q&A with you all, our attendees. Please note, however, that one of the discussions was pre-recorded in advance due to time zone differences. We have the Q&A feature on for attendees to submit their questions. And our very own FPF, Kelsey Finch, will help raise questions to the discussants and authors. We'll do our best to get as many questions as possible under our limited time circumstances. We also engage everyone to look at our PBPM digest, which has included all sorts of helpful information, including author bios, summaries of the winning papers, a summary of our winning student paper, personal identifiability of user tracking data during observation of 360-degree VR video, as well as their honorable mentions. So without further delay, I present to you Amy Cyphert, professor at West Virginia University College of Law, presenting her paper, Tinkering with Machine Learning, who is joined with discussant Ilana Zaidi, assistant professor at the University of Nebraska College of Law.
Okay, fantastic. So I could not be more pleased to, can you guys hear me? Yes, all good? Okay.
I can hear you.
To present this paper today, Tinkering with Machine Learning, the Legality and Consequences of Online Surveillance of Students. And it offers a great overview of different potential challenges, just how schools deploy machine learning in particular to monitor students' social media, particularly for content that might be considered harassing or threatening to other students, teachers, or administrators. It summarizes recent scholarship and discusses the potential for First Amendment challenges when students are disciplined for online speech, and also more generally for schools monitoring of social media overall, perhaps exploring the concept of perhaps treating it as a prior restraint, which would trigger heightened and generally fatal constitutional scrutiny. She reviews how the seminal case Tinker that noticed that students have free speech rights, although they are more limited in school spaces, might apply to the online environment, and discusses some directly applicable, well, some case law that is mostly applicable let's put it that way, and tries to reconcile different opinions that don't really come out either way, and in fact, somewhat contradict each other. She also looks at other ways that social media monitoring might trigger problems with the Fourth Amendment, particularly as schools might request access to students' accounts, and that might be considered an unreasonable search and seizure. And lastly, points to potential problems with disciplining students for what happens on social media in a way that may disproportionately impact minority students and thus trigger concerns with equal protection. Her policy recommendations are interesting in this space because they focus not as much on regulatory reform, but really institutional changes that schools might implement, which of course is something that is much easier to do than changing laws, as everyone listening to this no doubt knows. And these include investing in higher quality school counselors to address these issues rather than outsourcing them to private companies that provide these online monitoring systems, giving parents and students more transparency about what these applications are doing and how they work, and perhaps if they have any privacy recourse or options to with respect to these technologies. And lastly, and I think importantly, reflecting a lot of the recent research that has come out about really being more thoughtful about how schools and other institutions implement machine learning, given its potential inaccuracies, inefficiencies, actual ineffectiveness in many cases to promote the goals that it's being implemented for, and also the possibility of algorithmic bias and really perpetuating the inequalities of the status quo. And with that, I wanted to ask a few questions. One is, you write about some of the algorithms that are fueled, the sort of machine learning algorithms that fuel a lot of the sort of automated monitoring of students' social media. There's been a lot of discussion about these issues. Why does that matter in this case?
Great. Well, thank you so much. First of all, it's really an honor to be speaking with everyone today, but especially to be speaking with you. Your own scholarship in this field is phenomenal. So I'm looking forward to our conversation. I think that, first of all, I'm so blown away by the FDC chairwoman. Wow, that was incredible. And I was taking so many notes, and so much of what you're talking about is what I focus my scholarship on. It's thrilling to have someone in your position really keyed into these issues. And she talked about algorithmic bias, and she talked about other things. Sometimes machine learning is, of course, just a way of doing AI, a way of doing artificial intelligence, where instead of simply programming a computer to do a specific task, you're actually programming the computer to update its own code as it works and to teach itself, hence the learning part of machine learning. That's exciting because it's a real advance forward in the field of computer science and AI. It's concerning because there are massive issues of interpretability and explainability with machine learning algorithms. So we may have, here are the inputs and here's the output, but it's a bit of a black box in between. That's troubling from a legal perspective, of course, because we want to be able to interrogate these algorithms and understand, well, why did you reach that result? Was it for a permissible reason, or was it perhaps because of bias in the data set or bias otherwise? So I think that the fact that some of these algorithms are fueled by machine learning adds an extra layer of concern about making sure that they are not, in fact, perpetuating bias. We know so much about the school to prison pipeline. We know that being disciplined while you are a student can really put you at greater risk of later incarceration. And we know that there are real disparities in who is disciplined as early as preschool, which is really kind of stunning. I wrote an article about racial disparity in preschool suspension and expulsion rates. And I had to wrap my brain around the fact that preschool expulsion is a thing. So I think that the idea that these algorithms are being used to surveil students and that we don't even fully understand how they are reaching the outputs they're reaching should give us all pause.
Fantastic. And so this area is getting even more exciting on several fronts. The first is the case that is going up in the that is going for cert in the Supreme Court, based on a Third Circuit case in which the court ruled that the First Amendment did not allow public schools to punish students for speech outside school grounds. That case is Mahoney. Do you have any take on that and what we might see?
Sure. So I think first of all, let's acknowledge the evolution of the technology. In my article, I talked about a pair of Third Circuit opinions that were a little earlier, and those dealt with students making fun of their principals on MySpace. We are now up to MySpace. Yes, that dates it, right? We are now up to students being angry on Snapchat. So that's what the case that was recently granted cert. The Third Circuit, as my article discusses, has set itself somewhat apart from the sister circuits in that it's taking a fairly, I guess I would say, aggressive stance that Tinker is within the school walls, the brick and mortar school. And so you cannot discipline students for speech that they made outside of the school, outside of the school day, outside of the school walls. And of course, the case that was recently granted cert out of the Third Circuit involved a student who spoke on Snapchat on a Saturday from a store, so not during the school day or within the school. And I think that it's telling that the Supreme Court has granted cert, because I think that this opinion does stand apart from other circuits' opinions. And so there is a circuit split that the court will want to address. And it'll be very interesting to see how the courts, which includes several jurists who are prominently known for their defense of First Amendment rights, how they will square that with the ideas of, well, but what about speech that disrupts the school day or disrupts school safety? And I think it will be a very interesting case to watch, and I'm excited to see what happens.
And I think there's a really, certainly since this case went into motion, there's been a significant change in where we conceptualize school is occurring with the advent of Zoom school. I think that more than anything else, perhaps, social media is not quite, is not really school in the same way as actual Zoom school. But I think that has really brought home to people that schools can exist on planes that are not physical necessarily. So how do you think COVID might implicate sort of the overall trends here?
Yeah, when I first wrote this article, people said, oh, that's so interesting. Though, of course, not very many kids do online learning. And then COVID happened. Like the chairwoman, my 3 children are learning from home as well. And I think a lot of our kids are learning from home, either on a full-time basis or on a part-time basis. And so now we clearly are outside the physical brick and mortar school, but we're still within the school day. And we're on a school platform sometimes. So that's going to complicate this question. I actually think that issues of speech there will be very different than the issues of speech in the case that the Supreme Court has granted cert to, where you were both outside the school and outside of the school day and not really on any type of formal school platform. I think that's going to change. And we may have to have a third category that the court has to address, although hopefully kids will be back in school long before then.
Whew, one can hope. So Lassa, this case, does deal with predominantly, social media monitoring, right? But I'd like to focus the attention on a lot of these cases that you bring up really are middle school, sort of high school students. Those are the ones who are seeing do this. Why do you think the privacy concerns are particularly relevant to school children?
Yeah, I'll answer that, and then I know that they would like us to turn to the Q&A, but I think that, Chairwoman did an excellent job of talking about Edtech and how important this is. I think when we think about things like surveillance capitalism and how valuable our data is, the data of our children is especially valuable. Advertisers like to form those brand alliances early on, and if we are able to know a lot about children that's commercially really valuable, it's also really frightening to think that people are going to have more and more data about our children. Children are already vulnerable. And now that especially many of them are forced to learn online, I think that we have to be even more careful. It's just not a choice. Our kids don't have a choice. If they want to go to school, they have to be on these platforms using technology that's been provided to the schools for free at what cost?
Super. So there's a great Q&A here. Jill submitted, with students attending school remotely, but still being monitored, really in the COVID situation. Are constitutional claims like the First and Fourth Amendment more compelling now that on-campus safety is physical safety is perhaps diminished? Thank you.
That's a great question. So I can actually see that cutting both ways. On the one hand, the questioner is right. There's less of an opportunity for school violence when all children are home. Thank goodness, that's been one upside of all of this. At the same time, as I said, I think that there's a better chance for saying schools can't discipline students when the speech is both outside of the school building and outside of school hours and is not in a school recognized activity. I think where we have online learning, we have online classrooms and we have teachers who are present, and it's more akin to the traditional school day. And so I think we'll be sort of more back in the tinker arena with that. So I think that we may end up with three categories, right? One is students who are physically in the building who are doing school, and that's the traditional. Then we'll have students who are actually outside of school hours, outside of the school building, and outside of school recognized platforms. And then we'll have a middle ground of students who are home, but doing recognized distance learning.
So last quick question is, what about the hardware? So how might it matter if a student is using a school device or say a family-owned device?
That's a great question too. And I think it's not just the hardware. I think you would also have to think about the software. Is it a school platform on a family device? If it is a school device, I think that the monitoring, there's less grounds to object to the monitoring. I know when my children's Chromebooks were sent home as part of the online learning, they had to sign a somewhat draconian agreement that their teachers could monitor them at various things. And I looked at it, and my 5-year-old had to sign it. It was interesting. But I think that there's going to be less grounds for pushback when it's a school supplied piece of equipment, but I don't think there are no grounds for pushback. And I think that absolutely, as my article points out, and as I think the chairwoman said, we need transparency for families. Families should be involved in these decisions. They should be able to understand what they're being asked of, and they should have a voice in speaking up and in helping to formulate policies that work for schools and families as well.
Fantastic. I see that our time is up, but it's been great talking to you.
You as well.
Thanks for bringing this to everyone's attention.
Thank you so much.
Thank you, Amy and Alana, for starting us off on an incredibly important topic, one that I'm sure many of the attendees are grappling with in their own personal lives. And next up, we have author Clarisse Girot, Senior Fellow at the Asian Business Law Institute, presenting her paper, Transferring Personal Data in Asia, in a pre-recorded discussion with Anupam Chander, professor at Georgetown Law. Again, this discussion was pre-recorded to accommodate the time zone differences, and we will be unable to take questions for this paper.
Based in Singapore, runs a number of projects to facilitate the convergence of business laws in Asia. And I'm leading a project on data privacy laws in Asia.
Hi, Clarisse. It's such a pleasure to have a chance to talk to you about your award-winning paper. First of all, congratulations.
Thank you, Anupam. Thank you so much for the opportunity.
So your paper is titled Transferring Personal Data in Asia. It surveys 14 jurisdictions. Can you just tell us a little bit about the scope of your project, who your audience is, what your goals are?
So my organization, the Asian Business Law Institute, which is based in Singapore, runs a number of projects to facilitate the convergence of business laws in Asia. And I'm leading a project on data privacy laws in Asia with an initial focus on cross-border data transfer regulations. So what we're doing here is we're trying to propose solutions to different jurisdictions that we cover, 14 in my case, to facilitate cross-border data flows, harmonize, well, rather make the regulations converge and make practical suggestions for them to implement solutions that are working for businesses, but also drive better protection for individuals across the region.
Terrific. That's a noble goal across the varied landscape that you're dealing with. It's 14 jurisdictions, and can you tell us a little bit about why those 14 jurisdictions that you've selected?
Sure, definitely. So the 14 jurisdictions are basically those jurisdictions that have data transfer provisions in place, whether data protection laws with data transfer provisions in them, or countries that are just about to have data protection laws in place with data transfer provisions in them, but also those countries that have data localization provisions actually in place right now, like Indonesia, for instance, or Vietnam.
Terrific, terrific. So what are the big picture takeaways? How are countries approaching cross-border data flows?
So the big picture, in Asia, everything is big, right? So the picture is big in itself. We are in a region which is not a bloc, which is a mosaic of very different countries, as you know, very dynamic economies. Despite COVID-19, it's a very vigorous economic environment with a lot of trade happening within the region, and data flows underpinning this trade. So there's, we have a variety of countries. We have countries with very advanced data protection regimes historically, like Hong Kong, Japan, Korea, Australia, New Zealand. We have countries that are newer into the picture, particularly from Southeast Asian nations. And we have very big countries, of course, very big neighbors, India and China, for instance, not to name them, which are working on their data protection laws with massive data transfer provisions in them, and which are probably going to be game changers in this region. And so the landscape is complicated because these jurisdictions are, of course, very different. Their economies are different. Their approaches to the regulation of data and data flows in particular are different. So we're talking digital sovereignty, we're talking trade, we're talking protection of human rights in certain jurisdictions, and very often a combination of all of those. So it's a complex landscape, much more complex than the EU landscape, which I know well, and definitely more complicated than the US landscape, which is in itself fragmented, actually.
So the interesting comparison to the EU landscape as less complex, even though it has almost now double the number of states than that you have surveyed, and so that's fascinating. So let me ask about the jurisdictions that you looked at. Are there any that, you didn't take a position in the paper, but I'm just curious whether or not, are there any in the, of the 14 jurisdictions that you see might have particularly attractive set of data transfer provisions, ones that seem more consonant with the recommendations you make in your paper?
Well, something you learn pretty fast when you arrive in Asia, like me 6 years ago, is that there are no models, right, in Asia. Each country is different, and each of them will basically approach these issues differently. And there will be variations between legal systems that will be too important to bridge, even though there will be similar inspirations between these legal systems. So for instance, Australia and Singapore have very similar approaches to data regulations, but their approaches to the regulation will be different. So one of them will be based on accountability. Australia and Singapore will be more more GDPR-based kind of model. So we have different approaches here. I would say there are different types of let's say, big families. You have the families that are very much pro data flows, typically Singapore, Australia, New Zealand, Philippines, Japan, and these will basically implement data transfer provisions that are fairly generous in their approach, with a large number of data transfer requirements, mechanisms, and tools that are available for businesses to transfer data cross-border. And I think this is the model that is trying to prevail in this region, next to other models like those promoted by China and India, which are of course of a different nature.
So the GDPR, for example, has a whole host of models for transferring data outside. And I see the Japanese model particularly has that as well, just a very large list of possibilities for transferring data outside.
Yeah, definitely. GDPR is not truly a model, but it's a source of inspiration throughout the region. And I think we see here maybe the power of civil law systems, if you will. GDPR has become a model, not necessarily because all countries wanted to follow it, but because it was readily available on the shelf, for those countries that were, getting started and didn't have a data protection law before. And whether we like it or not, the epicenter of lawmaking in area of data protection and privacy has been, Europe over the last years, and many countries are actually civil law jurisdictions here, and they, it was not very difficult actually for them to take the text and implement it. That said, it's not a model in the sense that it's GDPR is still, tailored for a very specific kind of setting, which is truly Europe, and Asia is very different. Sometimes I find GDPR too sophisticated, of course, for some countries here. That said, it's better to have a model to follow than none.
And so tell me a little bit about enforcement. These rules, as you describe in the paper, are still new generally, but tell us a little bit about what kind of enforcement you're starting to see or expect, maybe.
We don't see a lot of enforcement. There's very little information out there that's available. Very few regulators have started enforcing their laws at all, to be frank. The provisions on the powers, the enforcement powers of regulators are being beefed up pretty much everywhere. So we can expect enforcement under the data protection laws themselves. But we see enforcement under the data localization requirements, which are different. And that's typically in China, in India, in Indonesia. There's not a lot of information out there on how these laws are being enforced, but they are. And companies are making themselves compliant because there's just too much at stake for them if they do not comply with these localization requirements. But enforcement is very much uncertain at this stage. We have to wait and see. But in a couple of years, I think we will see more concrete decisions come out.
Great. And are you seeing a lot of countries setting up DP, data protection authorities, or how is that? What are you seeing on the ground with respect to kind of ramping up to enforce?
Yeah, definitely. I mean, data protection authorities or commissions, depending on the structure, are being set up throughout the region. So it's basically the common model. There is a dedicated data protection agency. Whether it's independent or not by EU standards, if you will, there will still be an agency in charge, with some notable exceptions. For instance, in Indonesia, there would be no talk about having a dedicated data protection authority anymore, which came as a surprise. And then in some jurisdictions, well, again, typically China, Indonesia, Vietnam, at this stage, we're seeing more ministries in charge or authorities that come more from the cybersecurity, national security domain. So they're unusual data protection authorities, if you will.
So in China, there has been a fair bit of enforcement, with respect to cyberspace generally. I think the history, as you rightly point out, there's a cybersecurity aspect angle to that, but it's been employed in a variety of ways. I think that example of enforcing it with respect to cybersecurity has led them to enforce with respect to a number of different areas as well. So there's, as there'll be apps that are outlawed because they are acting in ways that the authorities, the Cyberspace Administration, for example, feels are inappropriate, et cetera. So it's interesting to see just, the variations in enforcement targets, in the enforcement goals, and Hong Kong, as you know, the Data Protection Authority has long been very active, right? So you have a privacy commissioner that has been, has a jurisprudence that predates many across the world. So that's also fascinating. So yeah, so it'll be interesting to see how all these countries deal with the difficult questions and the kind of varied questions that we're encountering as to what and whether or not there are cultural differences in this process. How are you feeling about questions of culture? Are you finding that there are different that there is a concern for privacy in these places, or people are indifferent to privacy, etc.? How are you?
No, I think. Thank you for asking this question. If there's one thing that I do not want to hear anymore is Asians do not care about their privacy. I mean, this is just not true. Privacy expectations are here, they're on the rise, and you see it very clearly, even within China. You were mentioning enforcement. Of course, we have these very high profile cases, that target, sometimes American companies, of course, but I mean, there are also lots of enforcement cases at the national level in the local courts that show that individuals, Chinese citizens actually go to court and activate their rights. And actually Chinese stakeholders said, when Chinese citizens have a right, they use it, right? So, and we see that coming up, as well as in Indonesia, in Malaysia, in countries where you might not have expected a very mature data protection ecosystem to take form so quickly. The younger generation in particular is extremely motivated. It's 100% digital, has leapfrogged the desktop phase entirely. People have several mobile phones, and it's just a way of life, right? And there is a very significant concern about privacy. So we can expect governments to take this increasingly seriously, and in fact, they do. And this is what this crazy process whereby we see laws being passed and regulations being passed every day. It's very hard to keep up actually in this region. It's one of the most difficult job actually of privacy counsels and data protection officers across this region. Is just catching up with all the legislations and regulations that come up every day, precisely because there is a need to address these privacy expectations, which are truly there.
Well, that sounds like a lawyer trying to understand privacy law in the United States too. You have the CCPA and now you have the CPRA, and wow, trying to keep up with developments even in the United States, and then we might have a Washington Privacy Act and Virginia and New York and et cetera, et cetera. So we're that is the consistent feeling across the world of privacy, experts. But it's fascinating to hear of you describing that process in Asia as well. In the paper, you talk about COVID-19 and data transfer rules. Could you elaborate on that a little bit?
But first of all, the general context is that COVID-19 has pushed everyone online massively. We all know that, and it's true in Asia, just as everywhere else. So we all work from home. We streamline entertainment from home. We don't travel anymore, so we do everything online. That's a way of life. And this has done a lot actually to increase the privacy expectations of individuals and of businesses that really want to be careful about what they do. Also in a context where a lot of data breaches, the APAC is the epicenter of data breaches, right, globally. So we know that. And therefore, all this data that's being moved online, the combination of all of this makes it extremely important to protect data better. And at the same time, sort of preventing the free flow of data is very dangerous. We've seen that clinical trial data, for instance, could not be moved around anymore because of localization requirements. We've seen that Indonesia has asked data, clinical trial data from Brazil, for that Chinese vaccine. So we have a bit of this schizophrenia, if you will, where we need the data and the laws go against, the flow of that data. And this is where we see that there is a need for greater consistency of data transfer regimes, not only to facilitate trade, but simply because it's a necessity in today's life, and particularly in times of crisis. This goes beyond trade. This is crucial.
Clarisse, thank you so much. It's such a pleasure to learn from you, to have the opportunity to speak with you about your fantastic paper and the important work that you're doing. Thank you again.
Thank you, Anupam. Thank you so much. Thanks, everyone.
Thank you, Clarisse and Anupam, for providing us all with a useful guide on navigating the laws and regulations in the Asia-Pacific region. For our third winning paper, we have author Britton Heller, counsel at Foley Hoag, presenting her paper, Reimagining Reality, joined by discussant Joan O'Hara, Senior Director of Public Policy at the XR Association.
Thank you very much. I am thrilled to be here, thrilled to be a part of this very important event, and probably even more thrilled to be able to speak with Britton Heller about her incredible paper on immersive technology and human rights. Working in this space, I'm thinking through these challenges all the time. The XR Association is fiercely committed to the responsible development of this technology, which we anticipate will be ubiquitous within the next 5 years or so. And two of the central concerns that we're always thinking about are privacy and conduct in immersive technologies. Britton's paper is not only insightful, but I think truly original in the points that she raises and the way she frames the issues. So rather than me providing a summary of your paper, Britton, why don't you tell us a bit about it and what prompted you to write it?
Sure. Thank you for having me here today. I'm very excited to talk about this work and very grateful to the Future and Privacy Forum for hosting. I became involved with virtual reality about 5 years ago, and I can't describe to you the magic that it felt to first put on a headset and to understand what this new technology would mean. In the paper, I interviewed Dr. Tom Furness of the Virtual World Society. He was one of the original inventors of VR, and he describes it as being akin to the splitting of the atom. I also, as a human rights lawyer, found that when there's a new technology, there's always a lot of hype and excitement about it, but at the same time, there's the potential for unanticipated harms. In my practice and in my life, I've been an anti-online harassment advocate. I actually brought one of the first cyber harassment lawsuits back in 2007 when I was still a student at Yale Law. And that really tested the limits of online anonymity and accountability for those type of actions. So in my practice now at Foley Hoag, I work on global business and human rights and really trying to integrate freedom of expression with public safety.
Can you talk to us a little bit more about your experience as a plaintiff in the AutoAdmit case, which was about anonymity and harassment online, and how that sort of impacted your thinking about harassment in a virtual space?
It really led me to believe that harassment needs to be taken seriously in whatever forum it occurs in. So the 10-second version of the lawsuit was that it was an online forum that was supposed to be about law school admissions, but it wasn't. It targeted women and minorities like myself and other people. And I asked the website to take it down because it was impacting my ability to get real jobs. And they said, you'll have to sue us. And so we did. It was a suit designed to see if average people could get redress when something like that happened. And the answer at the time was no, not just based on Section 230 of the Communications Decency Act, but because it's so challenging. And I saw the potential for those harms emerging in VR. Just because a world is virtual doesn't mean that the activity in it doesn't have bodily and psychological impact. Right. And that's the potential for harassment in VR. Jessica Outlaw, who's a wonderful scholar in this area, talks about this and explains that it feels real. So.
Right, exactly. That's the wonderful thing about these immersive experiences is that they do feel real. You really do feel that you're transported to another world, another space, and that you're interacting with people as if you were in a physical world. Mm-hmm. But when it comes to the potential downside of issues like harassment, do you think that it elevates it or makes it potentially even more impactful to be harassed in a virtual space as opposed to a 2D online experience?
I think it is potentially more impactful because you don't realize that it does feel real. Some of the people I interviewed for the paper talked about how these experiences are actually translated neurologically like in real life experiences. So it's drawn on the brain in permanent ink, is what somebody said. This is not like next generation social media. There are psychological and bodily components that make it very, very different. And so there's no separation between you and the objects of your interaction, just like in the real world. So I think that this has increased likelihood of harm as compared to harassment on social media or on the internet.
You talk a little bit in the paper about conduct and setting parameters and putting people in the right frame of mind when they enter these spaces. Mm-hmm. At the XR Association, we've published a developer's guide to help developers think through these issues and create appropriate social norms. Although the technology is still in its development stage, it is out there. There are millions of people that are using it for gaming, for entertainment, for social interaction. Are there any platforms or companies that you feel are getting it right at this point, and why?
I think I can identify best practices rather than calling out individual companies, because every company can do more. Yeah. The best practices include localization of data in the head-mounted device that you use to access your AR or your VR. It also includes having moderators, terms of service banning harassment that are enforceable, having rules clearly posted and reminding your users of the expectations of behavior in the space, having pause buttons, having mute buttons, having safety bubbles. So these type of things, the best type of protections will blend both hardware and software-based protections.
We've got a long road ahead, but I think in the industry, people are taking this very seriously. I really want to get it right. So as long as there's a commitment to set the right boundaries, I think I for one, am optimistic that we will get there. You also discussed in your paper the concept of biometric psychography, yes, which I believe is a term that you created.
Yes, it is.
Just another reason why the paper itself is so fascinating and original. But you're talking about combining sort of biometrics and impressions, the way people think about certain things, their preferences. Can you tell us a little bit more about why you feel that these two areas are merged together when it comes to immersive experiences?
When you look at immersive experiences, I like to think of it as the like button on steroids. The functioning of virtual reality requires sensors which implicate fundamentally private data. And this is what makes this technology different than the internet and different than social media. the type of information that the sensors get, like eye tracking information, is, I argue, it's not covered by traditional biometrics law. This is because traditional biometrics law is centered around issues related to identity and also the coverage of data. If you look at the way biometrics laws are crafted on the state level, it would exclude physiological data that determines a person's likes, interests, or motivations. That's not covered. Biometric psychography is a term that I invented for a novel type of bodily centered information that's not linked to your identity. The companies know who you are, but your interests, what you like, what you dislike. And these may be things that are occurring on a less, on a subconscious level. Like in the paper, I use the example of a sports car. If you see a sports car and your heart races a bit and your skin gets a little more moist and your pupils dilate, that is not a conscious response. Right. And that can be used to indicate that you like what you're seeing. Similarly, physiological reactions to things can indicate propensity towards illness, who you're sexually attracted to, whether or not you're telling the truth. And I don't think people consent to give away that type of information when they're playing a video game in VR.
Yeah, exactly. I mean, truly unique challenges. And I know that we need to go to the audience question, but just really quickly to follow up on that particular point. You know, Congress has been wrestling with a federal privacy law for quite some time, and we'll tackle it again this year, no doubt. Do you think this is something that they can and should consider as they're looking at a comprehensive privacy law?
Absolutely. Another distinction with VR and AR is that it records not just your reaction to stimuli, but the stimuli itself. So that type of information could be highly valuable to advertisers and other types of companies and even government purposes. Part of the challenge with VR is that there is this compilation of new types of data sets that was not anticipated by previous laws. And so I think that is some of the advice that I would give. I'd give 3 different points of advice. One is to keep human rights at the core. And I see there's a question about kind of the cultural relativism of human rights, but if you actually look down at freedom of expression, most countries and cultures around the world have more in common with each other than you'd think. Yep. And you can use Cohen's norms across the globe to really root human rights in precepts of human dignity. So what happens with freedom of expression and public safety when new media blends offline and online worlds? That's really the question I think we should be looking about. And it brings the most formidable challenges in both of those environments. I think that the regulators should rethink what biometrics mean, because in VR, the way that you tilt your head and the way that you gesture are as identifying as your fingerprint. And I don't think people realize that. This blend of data sets was not contemplated when the statutes were written. And my last point is, like I said, beware the compiling of unusual or novel data sets. There's a potential for another Cambridge Analytica style violation of public trust, I believe, if companies don't get on this before it's a problem.
And the aggregate of all of this information, as you mentioned, is it creates an entirely new problem.
It does.
Or challenge, I should say. But Marcus, do we have time for the audience question, or have I talked too much?
I think we're out of time now.
Oh, I'm sorry. All right.
All right. Thank you for having me. It's been a privilege, and I look forward to discussing this with anyone who's interested in the paper. Thank you.
Thanks so much, Britton. And I would absolutely very highly recommend that everyone should read this. It's an eye-opening paper. Thank you.
Thank you. Thank you.
Thank you, Britton and Joan, for providing us all with a useful reminder of the human rights implications present in VR and privacy generally. Next up, we have author Tiffany Lee, visiting professor at Boston University School of Law, presenting her paper, Privacy and Pandemic, joined by discussant Jared Bomberg, senior counsel with the U.S. Senate Committee on Commerce, Science, and Transportation.
Hi, Marcus, thank you. And hi, Tiffany. Hi to everyone watching. So I'm really pleased to introduce Tiffany Lee. Tiffany is a clinical assisting visiting professor at Boston University School of Law. Tiffany is an expert on privacy, AI, and technology platform governance. And her paper, which is entitled Privacy in the Pandemic, Law, Technology, and Public Health in the COVID-19 Crisis, couldn't be more timely and useful to people like me on the Hill. This article is the first comprehensive account of privacy impacts related to technology and public health responses to the COVID-19 crisis. It shows that there's been unique characteristics of this pandemic, which have precipitated an increase in the use of new technologies, including remote communications platforms, healthcare, robots, and medical AI. Public and private actors are using new technologies like heat sensing and new contact tracing programs, which has led to a rise in both government and corporate surveillance, according to the paper, in sectors like healthcare, employment, education, and commerce. And Tiffany, if you could, I've summed up the paper, but maybe you could kick this off by summing it up in your own words.
Sure, thanks, Jared. I'm excited to speak about this paper with everyone today. As mentioned, it's very timely, unfortunately, because we are still in the middle of an active pandemic. There is an end in sight now, so hopefully in a few years, or in a few months maybe, we'll be in a different situation. But I was motivated to write this paper because I was thinking about all the different ways that the pandemic has changed the way we think about privacy. And a number of speakers today have already mentioned various things that really relate to this topic. I mean, first of all, just the fact that right now we're all sitting in our homes, many of us, in our offices, some of us, but for many of us, that office and home divide is no longer there. We have seen, for example, people's children, pets, roommates, and others walk by in the background of Zoom conferences and meetings. We've seen people, use the same type of technologies, both for work and for school, and for going to the doctor, attending a court hearing, any number of things. So I was interested in all of these aspects of privacy in the pandemic. And of course, I was also thinking about all the issues with things like contact tracing applications, or just the huge amount of coronavirus testing we're doing right now. So there are public health responses and technological responses that I think are really important to examine in terms of how the pandemic has changed the way we consider privacy and the ways in which we've changed our society's expectations of what privacy should be.
And there's so many technologies listed in the paper, which is somewhat alarming, right? But not unexpected. Could you talk to us about something that surprised you as you were researching this paper? Whether there was a technology, or whether it was technology, or maybe a deficiency in the law, or both?
So the paper is rather comprehensive, and there are a lot of technologies that I listed. The idea was to try to map out the entire terrain so we can get a high level understanding of what's going on. I would say one thing that surprised me, which was a common thread throughout the paper, was that there was almost always a privacy preserving way to do things. And I think we can see this with the contact tracing applications. When we first started talking about having digital contact tracing, so apps on your phone or otherwise to perform contact tracing, I think there was immediately a lot of alarm about what that might entail, right? People thought maybe this meant tracking location data. Maybe this meant, the government or Google or someone taking all your data with no limitations. But that hasn't been the case. And I think that's been an optimistic, a positive surprise. That almost immediately, researchers were able to make privacy-preserving methods for digital contact tracing. And even the large corporations that we've seen, Apple and Google released a privacy-preserving exposure notification tool. Now, of course, different states have implemented this in different ways. Some of the state apps have been more privacy-preserving than others. But I think the important takeaway is that there was a privacy-preserving method to support public health. And that's a really important theme that I think we should always keep in mind.
You bring up the fact that states have implemented contact tracing differently and maybe are using the exposure notification systems differently. I recently read that Maui has required visitors to download Apple and Google's exposure notification system, its app. And it's interesting that I haven't seen many other jurisdictions take the same approach. What do you think are some of the benefits and drawbacks of requiring people to download these apps when they can?
So one of the benefits is if you require everyone to download the app, you have a higher chance of the app being successful. I think an early study predicted something like maybe 60% of the population needs to download the app for it to be really useful. And that's very difficult if it's an optional app. So on one hand, that might be really beneficial to force people to use the app. Now, on the other hand, of course, there are certain drawbacks. I haven't looked specifically into the Maui app, but some apps are not designed in privacy preserving ways. And that's a problem if you make every single person in a state download this app that may not be secure or may not be privacy preserving. It's also a problem in terms of trust. So if people don't trust the app, they may not use it. They may try to get around it, turning off Bluetooth or turning off their phone or using a different phone or something like that. And if you force people to download an app without clear privacy protections, there will definitely be a lack of institutional trust. And that's just a greater problem we have. I think many of the people here today have talked about this sort of a lack of faith in privacy protections from both the companies and from the government, and how we can really bring back faith in privacy in America.
So I have a lot of apps on my phone. One of them is the DC exposure notification app. At the end of the pandemic, or when I receive a vaccine, I don't know, probably at the end of the pandemic, I'm going to delete that app. But many people probably won't. What do you think is the likelihood that either that technology or many others that have been implemented now are pretty much going to be here to stay, either intentionally or inadvertently?
I think there is a great danger that many of the new uses of data that we've seen, new types of data collection, new types of data use, may be here to stay. And that's something we have to really consider. I think right now it's easy to justify new types of data collection and even new privacy violating technologies, because we think that we need to do anything we can to help stop the pandemic. The problem is, as you mentioned, it's really hard to roll this back afterward. So we have to try to fix this a bit now. And as other speakers have mentioned, it's really hard to do that by passing a new law. That takes a lot of time. So a lot of what we'll need to see is also companies really stepping up and the public-private partnerships really taking into account all the privacy issues we've been talking about.
And I know we're getting close to the Q&A portion, but maybe as a last question for me is, obviously there's a need for a comprehensive privacy law. And a lot of the issues that your paper speaks to can be addressed in some form by that privacy law. Are there any lessons to be learned or COVID-specific provisions that you think should be added to a comprehensive law that the pandemic has taught us that we wouldn't normally think about in a comprehensive privacy law?
So I think there are two specific things that we should look at in a federal privacy law that have been highlighted by the pandemic, although maybe not unique to it. The first is obviously the importance of protecting sensitive health, biometric, and genetic information. I think we've seen that a lot of our laws are limited because they only specifically look at specific types of information, what the definition of biometric information may be, as a prior speaker mentioned, or specific types of health institutions. And that doesn't cut it with today's public health responses. The second thing to look at, I think, that is really important is this idea of this blurring of the divide between cyber and physical, and thinking about the entire data ecosystem as the way to kind of regulate these harms, instead of just looking at the specific points of notice and consent that we previously thought about in terms of privacy.
Okay. Is this a good point to maybe open it up to Marcus, to the group for questions?
Yes, go ahead.
So I see some in the chat here. What can be done to increase trust and thus the usefulness of the apps?
So a few things I think can be done. The first is creating apps in a privacy preserving format. So we have research out there on how to do this. And if we release apps that are privacy preserving, we can then educate the public on what that means. And what it means to download an app that doesn't track your location all day, that doesn't store data in a centralized server. I think that will help a lot, that kind of awareness and education based on the foundation of privacy preserving methods.
And do you think that it's going to require an act of Congress to set standards to, ensure that people have more trust in the system, or are there other ways to achieve the same goal?
So this is definitely one area where we will need partnership, public-private partnership. We'll need pretty much everyone on board to change this. Right now, there's such a lack of faith in traditional institutions in terms of privacy. And by institutions, I mean not just the government, but also companies, the private sector as well. So we need better corporate standards. We need better laws too. And we need all of us to work on this together.
And there's another question here from the audience. If there was a comprehensive law in place before the pandemic, how would that have impacted the effectiveness of the response, both by the response by the federal government and by the private sector? And let me just add, what do you think it would have done to preserve privacy throughout the pandemic that maybe we've lost along the way?
So if we had had a national privacy law before the pandemic had happened, it's possible that all of these responses, these public health responses, and these technological responses, they might have developed in more privacy preserving ways. At the very least, we would have had a set of guiding principles. We wouldn't have had a set of patchwork laws as we have now that meant, a private contact tracing app versus a contact tracing app run by the state or a health institution might have a different set of rules. We wouldn't have had this conflict where, a private school and a public school might have had, again, two different sets of rules for educational privacy. So the federal privacy regulation could have really helped give us some consistency. And that consistency could have helped expectations and could have helped public trust in the government and corporations protecting privacy.
And maybe in our last minute, and this is sort of a out of left field question, but in terms of the vaccine response and rollout, have you seen any data to indicate that there would be stronger acceptance of the vaccine if privacy was better protected?
That's a really great question. I actually just published a co-authored paper with some scientists and social scientists on vaccine records verification, which is similar but not quite the same. This idea of having systems to record whether or not someone has been vaccinated. And another issue there, again, was a problem of trust. So I think there's a problem of trust with coronavirus testing, with the contact tracing apps, with the vaccine rollout, and even with the vaccine records verification systems. So these are all things that I think we have to tackle on a holistic level. And it's really hard to do it piecemeal, although right now that's what we're really left with. Trying to do the best we can on each of these separate issues as they arise.
Thanks. This paper has really given me and my colleagues some food for thought, and looking forward to talking to you further about it.
Great, thank you.
Thank you, Tiffany and Jared, for providing us all with valuable insight on a topic that has obviously affected us all to varying degrees these past 12 months and counting. For our fifth winning paper, we have with us today authors Kenneth Propp, Professor at Georgetown Law, and Peter Swire, Elizabeth and Tommy Holder, Chair of Law and Ethics at the Georgia Tech Scheller College of Business, presenting their paper after terms 2, joined by discussant Alex Joel, Project Lead for Privacy, Transparency, and Trust at the American University Washington College of Law. Mr. Joel was also previously the Chief of the Office of Civil Liberties, Privacy, and Transparency, the Office of the Director of National Intelligence. Gentlemen.
Great, thank you so much. This has been a fascinating discussion so far, and I am so pleased and honored to be discussing this fantastic paper with Ken Propp and Peter Swire. This paper came out in Lawfare and really addressed a very thorny issue, and you guys tackled it head on, which is to your credit. I really feel like the two of you represent exactly what this whole forum is about, which are people using academic rigor to tackle real world problems and come up with some practical solutions. And your paper really is an admirable example of that. So let's get into it. Last summer, as we all know, the court, well, as we all know, I don't know about the rest of the people in the audience, sometimes we think everybody knows what we're talking about. The Court of Justice of the European Union issued a ruling in a case called Schrems 2 that called into serious question the ability of companies to continue to transfer personal data out of Europe and to the United States, big tech companies, small companies, companies of all types. And the court in that case found that there were some deficiencies, ruled that there were some deficiencies in how the United States government accesses data for national security purposes, that there were some problems in our legal framework according to the European Union, and that those certain aspects of our laws did not meet European Union privacy standards. And one aspect of that in particular was a focus of their opinion, which is how we give people redress. How do people who have an issue about national security and its access to their personal data, how do they resolve that issue under our legal system? So without me further butchering your paper, let me turn it over to Ken first. And maybe, Ken, you can provide some more context about what caused you to write the paper and where does your paper fit into the overall discussion between the United States and the European Union on these issues?
Sure. Thank you, Alex, and thank you to the organizers of this event for the opportunity to present our co-authored paper. What I brought to this paper drew upon my background as a negotiator of data privacy agreements for the US government in the past with the European Union, and my current experience in teaching European Union law. So what I was trying to do was to make the judgment from the Court of Justice understandable both in the international relations setting and as a matter of EU law. And to put it mildly, this is a context that is highly aggravating for the US government, since what the European Court of Justice has done is to hold US surveillance law to a higher standard than it would hold the EU's own member states to. The standard it's being judged against is a fundamental rights standard that's constitutional in the EU system. It doesn't apply to the activities of the intelligence agencies of the EU's own member states in many contexts when they act on their own. There is relevant EU law in the form of national constitutions, in the form of the jurisprudence of the European Court of Human Rights, which is a different institution, a human rights court in Strasbourg, but that is somewhat less rigorous. And so the first reaction in the US from the judgment was outrage, that the US should not put up with it, that it should not negotiate, and that this was simply judicial imperialism and Eurocentric hypocrisy, to quote one of the prominent reactions. But in view of the economic stakes and the fact that the US has a history of eventually negotiating successfully with the EU on data transfer subjects, we thought it was important to take another shot at it and not to prematurely give up on negotiations. The second point is that it had been clear to many of us who've been involved in this negotiation, and that would include you, Alex, I think, is that the prospects of the privacy shield being sustained were never that good. And in particular, the redress mechanism that had been developed, the ombudsperson, which was a mechanism within the executive branch, within the State Department to look into complaints coming from Europeans about alleged surveillance of information that they had put in the hands of US companies and which was then transferred to the United States. That mechanism had its weaknesses, as the Court of Justice was quick to point out. It was a mechanism that was not independent in the European sense of the term, and it did not have the power to take corrective actions that the U.S. intelligence community was bound to implement. So it was not a complete surprise. It was an embarrassing defeat, and in our view, it set the stage for really a serious effort to try to get it right once more. And it was at that point where Peter Swire, with his deep knowledge of national surveillance law, stepped in.
Great, Peter. Could you hit the high points of your paper on that?
Yeah, I think I have 3 minutes. Okay, so here's the problem. As we've heard from Ken, it's a constitutional requirement reinforced by the Schrems II case that there needs to be individual redress in Europe. So an individual in Europe gets to test whether the NSA has violated that person's rights. However, under US constitutional law, there's standing problems. The standing problem is you have to show concrete injury before you're able to get into federal court. And that's a very difficult thing to figure out how to do. So what we did instead was look to a different model. When is it that a person, a US citizen or non-citizen, might be able to get an agency to do something that's required? And the model we use is the Foia, Freedom of Information Act. So if I want some data from the Department of Commerce, I don't have to be injured first. I get to ask the question. And the agency is under a mandatory duty to do the fact finding and to come up with Foia. And if they don't do it right, it gets to go to a judge. And so in our paper, we talked about statutory ways that Congress could create this mandatory requirement on agencies, perhaps the Privacy and Civil Liberties Oversight Board, perhaps others, to do a fact finding. And there would be an explicit statutory right to go to the Foreign Intelligence Surveillance Court, the FISC, on appeal. That could all be done in a classified way, and there would be a redress mechanism that would fit with European law. In December, I was asked to testify for the Senate Commerce Committee on these issues and added a whole extra 10 pages or whatever on non-statutory ways to do it, essentially through a combination of executive orders and memorandums of understanding. The agency could be obligated to do the fact finding. And then under the existing FISC authority to oversee Section 702 requests, the FISA court could still oversee and issue binding orders as an Article 3 judge. So we have both a statutory and non-statutory path. There's been strong interest from the administration in actually doing this as a way to solve the problems. And so it seems like perhaps we've provided a path that people can now consider on how to move forward.
That's fantastic. And if there are questions from the audience, I'll be watching it. It's open for questions and answers right now while we're waiting for one. If this is something that ultimately requires Congress, I know that you proposed something that does not require legislative action, but if the determination is made that legislative action would be helpful, what do you think of the prospects of something going through this year that would address some of these issues?
Yeah. I might, so there's a national security intelligence community aspect to it. So those are committees that would be very relevant. There's also a great interest from the commerce committees about the effect on global trade if we don't get some sort of an agreement. And so it's an unusual issue where in Congress you'd need committees that don't necessarily work closely together, also trade-related people, to figure out who's going to go first and who would draft it, et cetera. If there's administrative leadership and the administration helps with the creation of text, I think that could be helpful. But because it's a new statute that requires various bells and whistles to operate, it may be that the best way forward is to start with non-statutory approaches that start to build it, and that can provide a basis for Congress to try to create a bigger, more permanent superstructure about how to do it.
We do have a question from the audience. Leaving aside sort of the EU side of things and looking just at the US legal framework, do you guys believe that it is properly aligned with our Constitution, the Bill of Rights, and our values?
Okay. Sure. Having lawful activities by the government in the surveillance and other activities, that's we start the Constitution, the Fourth Amendment is part of the Bill of Rights, and so having effective redress and having judicial oversight is something that makes a lot of sense. And the whole system for foreign intelligence surveillance is to have Article 3 judges deeply involved in how even national security surveillance goes. So in some ways, this is filling in some gaps or providing some additional steps. But we've been rebuilding, as part of the review group after the Snowden things that President Obama created. And we recommended a lot of changes in this area, including having amici curiae in front of the FISA judges to have a back and forth with the Department of Justice and other lawyers. So I think this is moving along a path we've been on since the FISC was created in the 1970s, and it really is consistent with the American approach.
Let me just add one brief comment on that. It's important to look at this from a comparative perspective as well. As I mentioned at the outset, European governments do live under some discipline in this area already through the Human Rights Court in Strasbourg, and some of them through disciplines in their own national constitutional traditions. The German Federal Constitutional Court has even begun to recognize the rights of foreign persons in the surveillance area. So this is an important trend that is beginning to develop, and what we have suggested here, I think, would bring the U.S. well along into that mainstream.
So and maybe, Ken, you can follow up on that. Somebody from the audience has asked about data privacy laws around the world. More and more countries are enacting these data privacy laws. What are the implications, if I can just paraphrase some of this question, what are the implications of the current situation to other countries and how they protect privacy and how they deal with national security?
Well, it is certainly an evolving situation, and one of the interesting developments will be to watch how the European Union applies the implications of its own ruling to other countries besides the United States. That is not at all obvious at this point, but it is clearly the implication of the judgment that it must. There is also beginning to be a broad discussion of the question of government access to personal information. The U.S. government has committed to participate in a multilateral discussion at the OECD in Paris, and also the Council of Europe in Strasbourg intends to take up such a discussion. And frankly, the U.S. rules, aside from the question of redress, do not necessarily stack up badly against those of many of the other countries participating in those discussions.
Peter, did you have any final words to add after that?
Well, I think, Alex, as the questioner, my understanding is that you've been asked by the OECD to be involved in a multilateral project to try to understand principles for government access to commercial data. And when you think about Asian countries, including Japan and Korea, European member states, the United States, other OECD members, these are rule of law democracies. And if we can have convergence on how companies respond to legal process, then I think we have a much better chance to have a platform for adequate protections as data gets transferred from country to country.
Great, thank you. We'll let that be the last word. Thank you very much. It's a really good paper, easy to read. Look it up. It's on Lawfare. Thank you.
Thank you.
Thanks.
Thank you, Kenneth, Peter, and Alex, for a practical discussion around the individual redress challenge. And for our sixth and final winning paper, we have author Lauren Henry Scholes, professor at Florida State University College of Law, presenting her paper, Fiduciary Boilerplate, joined by discussant Sid Terry, legislative director and policy coordinator for the House Energy and Commerce Committee.
Well, hello there. I'm wondering, has my co-panelist gotten bumped off. I suppose I could just, okay. Awesome, he's here.
Nope. Okay, they put me on here. Right? Can you hear me?
Yes.
Fantastic. I will introduce you now. Lauren Scholes joined the College of Law in 2017 before coming to Florida State University. She was a fellow at the Project on the Foundations of Private Law and the Berkman Klein Center for Internet and Society, both at Harvard Law School. She was also a fellow at the Yale Law School's Information Society project. Before entering academia, she was a law clerk for the ACLU Massachusetts and for the Center for Democracy and Technology. Her paper today is the Fiduciary Boilerplate, which I enjoyed reading and has I have not stopped thinking about, and I look forward to having some questions and good discussion on it. So, Lauren, if you want to kind of summarize your paper for us.
All right, so I'm going to give an overview of my paper, which is called Fiduciary Boilerplate. What this article argues is that most of the most economically salient consumer firm transactions are better understood as not just contractual transactions at all, but not just contractual interactions anyway, but rather ongoing relationships of trust between the consumer and the firm. And that has important consequences for the responsibilities firms owe consumers. So for example, when you downloaded Zoom or initially joined many, many moons ago, Google to get Gmail or get a new account at an e-commerce site, at a certain point you probably almost certainly clicked register or I agree. That demonstrated your assent to a long series of terms that you naturally didn't read. But I argue in this paper that at that moment, two different things have happened. Not only may you have signed a contract, but completely separately, you and that company have begun a fiduciary relationship. And that fiduciary relationship places limits on what that company can do to you, the consumer, irrespective of the content of the contract. They owe you a duty of loyalty and they owe you a duty of care. And it also gives consumers rights of enforcement for breach of these duties, irrespective of the limits of enforcement placed in the contract. So the Delaware Supreme Court has put it, quote, when contracting parties provide for the arbitration of claims in their agreements, the arbitration provision, no matter how broadly drafted, can reach only the claims within the scope of the contract, and the fiduciary duty claims are beyond that scope. So it's a separate thing that's happening here. So why does that matter? Well, it forces substantive consideration as a matter of law of what information age consumers are owed to by the companies that they have relationship with. So much discussion about consumer firm relationships have come down to notice and choice simply because there's this idea that consumers are going to be bound to what's in the contract, and that's going to be their rights and responsibilities. And because of these arbitration clauses, we haven't been able to hash out so many debates about what's really going on because of these arbitration clauses. What's more, having fiduciary duties on such firms is there's a huge expressive value of this interest. It could reshape the set of interests consumers receive and expect. Law has an important expressive character beyond its coercive one. I really, really enjoyed the presentation by Commissioner Slaughter earlier, simply because so it's not just about every individual action. Law actually creates a public set of meanings and understandings between the state and the public, and it can clarify and draw attention to the behavior it prohibits. And so the big example of this that I like to think of is in the 70s and 80s, court rulings against sexual harassment changed that from sexual harassment in the workplace from being widely accepted as just part of reality, like we saw in Mad Men, to being seen as unobjectable wrongful conduct. And I would like to see the same thing happens with certain corporate privacy practices that we're seeing now. And with the fiduciary relationship that I propose in this paper, I would like to hope that many things we consider normal now would be both unlawful and considered wrong in a country where in a regime where fiduciary relationships are recognized in ongoing consumer transactions.
Thank you, Lauren. I'll start off by saying, first of all, that I think that compliments to the organizers. I think that we're a good pairing in that my boss, Congressman Schakowsky, has long railed against kind of the, advise and consent, notice and click through for a lot of online transactions. She's held stacks of paper up at the beginning of hearings for all of the types of, terms of service that she's agreed to. She sought to make them kind of have to be in plain terms. She sought to try to make failure to enforce them or change them in unfair ways, Section 5 violations of the FTC Act. But I think that what you really have proposed here is novel and really thoughtful. Despite my initial hesitation, because I spent a good part of the middle of the previous decade working on the Obama Department of Labor fiduciary rule, and that was just that was a pit of horribleness. So I had, despite my negativity there, one of the things I like the most about it is that I think that it provides quite a bit of flexibility for different business models and technological growth, while also kind of protecting a core basis of what's good for the consumer. To that end, though, I mean, I think that we see all kinds of internet businesses, all kinds of businesses that exist online and in that data collection world. Most notably, kind of most famously, there is, the ad ecosystem. So my question for you is, how do you see this interacting? How do you see targeted ads kind of operating under such a regime?
So I think this is a really fascinating question. So as I say with my initial example, in order for a company to be bound by to have a duty of loyalty or a duty of care to a consumer, under my approach, there would have to be a fiduciary relationship. So if it's a company that you have a relationship with, then this standard would be applied. But if it's a company that you don't have a relationship with, they would not be at all affected by this framework. There would have to be just sort of maybe other standards for limiting advertising. But I think it gets interesting when we think about, all right, what happens if this advertising is actually being presented to you by a company that you're in a fiduciary relationship with? Like I would say you would be with Google or Facebook. I would say it depends on what is being advertised and how. If, let's say, for example, they're giving you an ad for more paper because your printer knows you've run out, that's one thing. And I think that's something that many consumers would appreciate, because just the fact that the company's making money isn't a problem as long as it's not affirmatively hurting the consumer. It's fine. I would say on the other hand, I think it would mitigate against advertising payday loans, because the company knows your bank account is linked, right? Because this is actually something that could using opportunism to enrich, let's say, get more advertising income in a way that could actually harm the interests of the consumer. So I do think it depends on what's being advertised and who's advertising.
Well, that sort of gets at I think the other, kind of look at the business models for platforms too. We had Tim Kendall in our subcommittee testify, and he compared it to tobacco. Saying that like the engagement side of the business, as opposed to the back end privacy side, which we're talking about here, is meant to be addictive, right? So then, and I think it's interesting when you start thinking about it. And we had earlier, I think the virtual reality discussants kind of talked about this a little bit, where like how all of a sudden does what you are seeing how is that impacted by what they know about you? And I think that's kind of where I think it's most exciting what you're talking about.
Awesome. I think the line drawing exercise is really, really interesting. And I think it's just sort of looking at the examples and finding things that are in common. I mean, payday loans and more paper are like pretty extreme examples. I think people intuitively, and literally, I think that many platforms don't even advertise payday loans anymore. Things that actually harm their consumers is what I'm concerned about. But there is this argument, on the other hand, to what extent is all advertising somewhat addictive and playing on our weaknesses, and to what extent should it be allowed? But I do think you should be cabined by the duty of loyalty if you're already in a relationship.
And then I don't know if we have any questions. If we do, somebody can jump in, but I have one. I think when I saw we didn't, do we have one?
You have one.
I think it just says, comments and says very interesting, right?
Check in the chat. There's a question.
Oh. Okay. I'll read it. What is the difference between an implied fiduciary duty versus an implied right? Example, the right of habitability and landlord-tenant versus an implied duty of care. Negligent standards of care for a particular profession / skill. Does it make any practical difference?
So this is really interesting. So an implied fiduciary duty versus an implied right. I would say that what I see as the difference here, and I think this is both the advantage and the disadvantage of fiduciary duties, right? Because an implied right, I mean, let's say a right of habitability it's a right to something specific, right? You need to have a habitable place to rent for a residential interaction. One of the features of this proposal that is really interesting is, well, a fiduciary duty implies a duty of loyalty and a duty of care, but what exactly that constitutes depends on the circumstances, right? So I do think that that's one difference, because I also think that one difference I would say too is an implied right, like the right of habitability in landlord-tenant. It's like it doesn't have to be in the agreement, it's just imposed by law. What I'm arguing in terms of these fiduciary relationships is this is actually what both parties wanted and intended, and it's simply the law recognizing what's already there. There is an ongoing relationship. The fiduciary does know they have this sort of position of power over them, and there is this relationship of trust. And this is just sort of holding them to the relationship that they've created. So I guess that's one difference too. Like, I don't think it's contrary to what parties are agreeing necessarily, whereas some implied rights, like the implied, I mean, these things overlap. I don't know, like the implied warranty of merchantability and the implied right of habitability are imposed at law because we think that that's what most people would assume would be there in the absence of a dispute.
I think we have one more question, so I'll go ahead and do that then, I think, if that's all right. How would you address the use of nudges or more troublingly harmful dark commercial patterns in the fiduciary duty analysis? Can you nudge consumers to do something that's in their interest if you're a fiduciary?
I would say it all comes down to opportunism and the foreseeability of negative consequences to the consumer. So, for example, a doctor is a fiduciary, a lawyer is fiduciary, a priest is a fiduciary. There are a lot of different types of fiduciaries out there, right? So this idea of nudges and dark commercial patterns, so these companies that we have these relationships with are using them. And I don't think that my proposal says they can't use them. I think where the line starts to be drawn is like, are you nudging them in a direction that's against their interest, right? So the pushing of, if there was that big documentary on Netflix, making lies more available than the truth, pushing people more and more towards conspiracies because they know that makes people click a lot. That seems to be a situation where making more money goes actively contrary to the interest of the consumer. And that's where I think it violates the duty of loyalty. If it's ambiguous whether or not it helps or doesn't help the consumer, or much less if it's something that benefits both, that's fine. It's like when it really seems like it's harming the consumer or could foreseeably harm the consumer, that's where I think would be against the duty of loyalty.
I think we're out of time. I thank you. I enjoyed this, and thanks to Future Privacy Forum and everybody. This was a great discussion. I'm honored to be part of it.
Me too. Thank you so much for your time, everyone.
Thank you, Lauren and Sid, for raising an incredibly important issue that needs to be analyzed more in privacy and legal circles, both in the US and abroad. A very fascinating discussion. And we've come to the end. A big thank you to all of our speakers that participated in this year's PPPM event. These papers and discussions will no doubt make us all more informed, prepared privacy professionals and advocates. I would again like to thank the National Science Foundation, our honorable co-host, Senator Markey and Congresswoman Daggett, and Acting Chairwoman Slaughter for helping make this virtual event special. I would also like to thank all the judges that took the time and energy necessary to read and select our winning papers and for making the 11th annual PPPM event a success. A special shout out, of course, to our finals judges, Mary Coleman, Michael McCullough, Amy Stepanovich, Jules Polensky, and John Verdi for their help as well. And of course, thank you to all of you, the attendees that joined us for our first ever virtual PPPM. We hope that this was a useful and informative event and hope that you can join us again next year. Thank you.